Hello, my name is attorney Masa Sam Foray, and I am founder of the Foray firm with offices in Chicago and in Houston. And I am back again today to answer all of your Illinois family law matters. So today's question is, my divorce was finalized years ago, but I recently learned that my spouse, my now ex-spouse, withheld pertinent information from me and from the court. What can I do about it? So this is a hypothetical that unfortunately happens to many people. So I understand this question to mean that you guys went through a divorce. There was an entry of the judgment of divorce, or the judgment for dissolution of marriage, as we call it in Illinois. And as a part of that judgment for dissolution of marriage, you made certain representations either in the paperwork itself, so either on the written divorce decree or the judgment, or you might have even made oral representations to the court under oath about certain accounts, certain assets, income, etc. And so what happens to a lot of people is they take the other person's word for it. When they say, I have one retirement account and not two. When they disclose an IRA or an IRA, but they don't disclose their separate pension from a prior employer. And so when you find yourself in this situation, generally speaking, to answer the question, you can do something about it. You can file what we call a petition for sanctions. And what sanctions are specifically is you're asking the court to find that somebody has done wrongdoing. In this case, they have purposely withheld and misled the court. They have failed to be candid or to engage in candor and honesty to the court and to you. And by virtue of that, you have been harmed. And to follow up with the scenario I just gave, meaning I got a portion of the 401k or the IRA that I was entitled to, but the court did not divide the pension that I was also entitled to a portion of, based upon their failure to be candid to the courts. And because of that, then you ask for them to be sanctioned, meaning you might ask for them to pay attorney's fees. You might ask for them to pay the fees that you might have used with an investigator to discover this new evidence. You might ask that they give a disproportionate share, of the pension, meaning, hey, as a sanction to slap her hand because she failed to disclose this information, I not only want you to divide the pension the way you would have done, and perhaps in the divorce, had she been honest, you would have divided it 50-50. But I actually now want you to give me 80% of that pension because of her wrongdoing. I want you to sanction her and to let her know that what she did was unlawful and it was a violation of the laws and the rules of court. So you can file a petition for sanctions. The question is whether or not that petition for sanctions would always be granted under this hypothetical. Not always. And that doesn't seem, necessarily intuitive. You would think that anytime somebody lied to the court, anytime somebody purposefully withheld critical information, like having a whole nother pension that they did not disclose, that they would automatically be sanctioned. But that's not the case. Why? The reason why is because when you are a litigant in court, whether you are represented by counsel or whether you represent yourself as a pro se or self-represented litigant, you have the obligation to do what we call due diligence. And what we mean by due diligence is, it means that you have the obligation to do discovery, to follow up on statements and representations that are made, to send subpoenas, to send requests for production, and to do a little bit of digging. So what you cannot do is you can't fail to do discovery, decide that you're just going to take this, take your ex-wife's word for it when she says all she has is a 401k, not even investigating whether or not she has a pension, not even investigating whether or not there are other assets that she has failed to disclose. And then go back before the court and say, hey, judge, I know I didn't do my job, but I'm asking you to redo your job or to redo the judgment for dissolution of marriage that you previously entered. The case law is very, very clear. You can't sit on your laurels and sit on your obligations and then go back in and ask for a second bite at the apple. So what's the takeaway from this video? The takeaway is you definitely don't want to withhold information. It's never right to lie, but it's illegal to lie to a judge. So don't put yourself in that situation. And if you are going through a divorce, it doesn't matter how simple or straightforward the matter is. And it doesn't matter how much you think you know about the other person's income or assets or debts. It's really very important to engage with a trusted family law attorney to make sure that discovery, or most importantly, full and thorough discovery is done, so that you know the totality of the marital estates, meaning you know the entire world of debts and assets and income, so that it can all be properly apportioned and properly divided, and so that your rights are protected in court. So I hope that this information was helpful, and I look forward to seeing you on the next video.